Add to stream. Here we go.
Here we go.
Okay. Hi, everybody. Thanks everybody for your patience. We're using a new streaming platform tonight called StreamYard, and it allows us to go live from multiple different platforms at one time. So I'm just going to give a little minute to get everybody on. I know that we've been giving everybody a lot of heads up that we were going to start at 9, but we're going to give everybody just a minute to come in. We are also blessed with attorney Lindy Urso this evening as a surprise. So thank you for joining us. We really appreciate it. We know that it was a last minute thing. Looks like we have, looks like we got a bunch of people on. All right, so let's get started. Kevin Barry, thank you for joining us. Lindy Urso, thank you for joining us. In case anybody here is new to what's going on, my name is Leanne Duquette. I'm the founder of an organization called Informed Choice Connecticut. We were fighting the removal of Connecticut's religious exemption for multiple years, and last year they passed the bill anyway. They repealed the religious exemption. In working with attorneys Kevin Barry, Lindy Urso, and Jim Mermigis over the past couple of years, we decided to form a plan to launch a robust legal challenge to the repeal of Connecticut's religious exemption. In doing so, we found some unique legal loopholes that Connecticut is experiencing that no other state in the nation experienced, and we are able to utilize those to form a good legal challenge. So let's get started. I just want to go right through the questions because I know it's been a long time. Everybody's been asking a lot of questions, so let's talk about what exactly was filed. We'll get right to the point here. So we filed two legal motions. The first was an actual lawsuit or a complaint in April of this year. This action will bring us to trial, provided we survive the state's motion to dismiss. I would like to impress the importance of this trial upon the public watching. Without sounding dramatic, this will be the religious freedom trial of the century. The reason this case is so nationally important, this is why people from outside of Connecticut have vested interest in this case, is because we are the only state in the nation to remove the religious exemption with a state-level Religious Freedom Restoration Act in place. No case ever has been brought like this in the country. There have already been hundreds of hours of legal research, writing, reading, strategizing. This is a rapidly developing field of law, and lawyers need to be on top of all the recent Supreme Court and District Court opinions. So we also may need to hire, outside legal experts, and we will need to house and transport all of our experts to bring them to Connecticut for expert testimony. The second motion that we filed was a preliminary injunction. This is essentially a restraining order asking the judge to halt enforcement of the repeal law until our trial is decided, which will allow children to, if we win this preliminary injunction motion, it will allow children to register for kindergarten and pre-K in Connecticut with religious exemptions. If we win, like I said, you'll be able to enroll. It'll be as if the bill didn't pass until the outcome of the trial is decided. Now, win or lose on this preliminary injunction, we still go to trial, provided we survive the 47-page motion to dismiss that's recently been filed by the state of Connecticut, and we'll hear more about that in a minute. The hearing on the preliminary injunction will be July 18th in Stamford. We do not yet know if this will be in person or remote. We prefer the hearing in person, but we will. Oh, I'm sorry, not the preliminary injunction. The motion to dismiss will be heard in Stamford on the 18th. My apologies. Thank you. So just a little bit of an update about what has happened since we filed. This Connecticut State's Attorney General's office has filed a motion to dismiss, which is customary. If you're being sued, you want to dismiss the case and make a motion for it. It's for over 80 exhibits. The hours that have spent meticulously deconstructing the arguments and rebuttals are massive, requiring all three attorneys to prioritize most of their practice time to dedicate to the Connecticut case. What are the next steps? The next steps are going to be a 6 to 8 week sprint for the legal team while the judicial process goes through its procedures. And I don't know if people here are familiar with the legal process, but it doesn't move very fast. The almost immediate need is funding to fight the state's 47-page motion to dismiss and keep this case alive. We need to defeat the motion to dismiss in order to make it to trial. That is the most crucial part. So next I have some dates of importance that are coming up. July 11th is our deadline. So just a few days away is our deadline to reply to the state's motion to dismiss our lawsuits. That is very important. And all three attorneys are going to be all hands on deck for that one. Just a few days later is July 14th, which is the state's deadline to reply to our objection to the motion to dismiss. On July 18th, the hearing will argue the state's motion to dismiss. This is huge. We have to survive this crucial step. On August 1st, the state's deadline to object to our motion for temporary injunction comes, and I didn't even write the date, but I don't know our deadline to reply to the state's objection to the motion for temporary injunction. And I know that the temporary injunction hearing is in August, but I didn't write the date down. I'm sorry. Lindy, do you know the date for the temporary injunction hearing?
Kevin has it handy. I don't have it handy.
I have those. We have to reply to the state on August 8th, and the temporary injunction hearing is scheduled for August 16th.
Okay, great. So who should know about this and why? This will be the religious freedom trial of the century. And the reason I say that is because Connecticut has unique legal protections that other states in the nation don't have. Something that is very important to consider is that Connecticut's model of grandfather everyone to phase out the non-vaccinated families will be a very dangerous precedent to set for the remaining 44 states in the nation who still possess a religious exemption. It will be very easy to come off all the states if they just grandfather everybody in and cut the freedom fighting army in half because their kids are grandfathered so they didn't fight. This is definitely very important. So our legal team has to educate people outside of Connecticut as well about why this case is paramount and of great importance. So they will be spending time networking with other people in other states regarding what's going on. Let me see here. I think that goes over the main gist of what we filed, when we filed it, what exactly it is. But I think I want to talk to the attorneys a little bit now. We can open it up to Attorney Kevin Barry, who's really been the quarterback since day one in Connecticut when we saw the writing on the wall. I couldn't have asked for a better offensive coordinator. I'm really glad that he's here, and he pulled in attorneys Mermigis and Urso as well. So Kevin, thank you for joining us.
And we are the offensive coordinator.
Offensive coordinator.
Always offensive in every possible way. Yeah. So I want to just highlight again, like for the national audience, and this case is nationally important, and I'm not sure if people understand that at the level they should, because there are 44 states that still have religious exemptions, and this Connecticut model of grandfather everyone, like New York didn't do that when it was repealed in New York, Maine didn't do that. California didn't even do that. California had two check-ins in first grade and seventh grade. So I think that's a very diabolical tactic by the pharmaceutical lobby, and that could spread across the country because that legislators are they're thinking very self-interested and short-term about their reelections. So if they just grandfather everybody in, this could be the new MO for taking away religious exemptions. And we have a great opportunity to stop that in its tracks in Connecticut. And we have 6 weeks to do it.
And we do have rumblings from other states that are gearing up to do the same thing that happened here in Connecticut. It starts off just a conversation between legislators, and then the hype builds, and then it gains momentum. And before you know it, it's gone. So this is very important to help Connecticut and try to set some precedent here for the rest of the nation to get our Religious Freedom Restoration Act, codified and solid protection.
And one thing I also want to say, and then I'll let Lindy chime in, but I think we're very pleased with the judge's sense of urgency when the judge was doing scheduling. Like the judge wants to possibly have a decision before school starts, so there can be some clarity for the parents of the 4 and 5-year-olds who are wondering whether they can go to school. So that's why it's moving pretty quickly. That's why we have to be in on Monday, and then the state we have to be in on the 11th. The state has to apply on the 14th, and the hearings on the 18th. So in the legal world, that's moving at lightning speed.
It's going to be a sprint.
And we're happy with that. We want that. Our plaintiffs want that. Every kindergartner wants that. And also on those hearings, July 18th and August 16th, if the schedule doesn't change, they'll be in Stamford. And we don't know yet whether it's going to be in person or remote. We want it to be in person. And I want to stress very highly that we welcome anyone to come to that hearing. We welcome the support, especially if you're the parents of an adorable 4 and 5-year-old who can't go to school. Bring them so the media can see like who exactly is feeling the pain of this repeal law. But it's not a protest You're not bringing signs. You're
Not a
not
rally.
no
There's no
outbursts.
sign.
Correct. Right. It's maximum professional.
Right. Right. Okay, good. Lindy?
And yeah, just following up on the judge, when we, you know, we chose carefully our plaintiffs and our jurisdiction, and I had this very specific judge in mind when we chose Stanford. Unlike some states, you don't get to pick a judge. You don't know who you're going to get, and we don't know that we're going to have the guy that we've had so far. But this is the guy we've wanted from the planning stages before we put a pen to paper, and so far we've gotten him. And we've already have a very significant legal victory already that's been looming over us. As many of you know, there was a dueling sort of a faction, a dueling attorney in the community who for his own egotistical reasons and others filed immediately an action in federal court and for media purposes, for fundraising purposes, and all reasons counterproductive to prevailing. Filed in federal court the day after, or the day the thing was repealed. That promptly got dismissed, and then much to our chagrin, he decided to file in state court, which is where we are, and we chose state court for a good reason. But the state had moved to join the two cases so that we would have to be stuck arguing and fighting the case out side by side with the other group that we just don't think is in this for the right reasons. And certainly it's not about them, but the point is we didn't want anything to do with them. Ours has been a serious challenge from minute one, and that's why we took our time with it, and that's why we chose where we chose, how we chose, when we chose. And we just found out last week that the judge denied, not only did he deny the motion to consolidate, but the state, when he asked the state, do they intend to try to move to transfer our case to that jurisdiction? The state said no. So we are in the clear. There's going to be no consolidation with what I consider to be a sort of a cancer on the cause. So we are free and clear. We have our own action as should be, and we feel really, really good where we are. But as Leanne said, I mean, we are all three of us inundated with work of our own, and this thing is going to require intense amounts of hours and effort. And I haven't really talked much about the fundraising part, but it is going to cost us a lot of money in lost business and missing business to fight this thing. Now, at the end of the day, that's not what we're in this for. We're here, and we've been fighting for 3 or 4 or more years alongside all you guys. We're not in it for that. But the simple fact is we are going to be taking food out of our families' mouths. So that's why I did feel it's important to come and join Leanne in this request for you guys to chip in if you can. But either way, you're getting our full effort, regardless whether you give nothing, something, a lot, a little. You're going to get the same effort. So don't worry about that.
Right. And one thing I want to add on to Lindy, that we're not consolidated means our case gets to proceed by itself in Stamford rather than being consolidated in Hartford. The Attorney General was trying to bring us into the lion's den of the state capitol, and we're much happier to be in Stamford, where
my home court.
It's a home court for Lindy, and also where perhaps the judges in the Attorney General's office, see each other at the golf course less.
Mm-hmm. So I just a question came in really quick, and somebody's asking for you to explain what the consolidation effort means. What does that mean?
So I'll explain. So what we feared and what we predictably happened is because the issues are the same generally. The issue we're both plaintiffs, groups of plaintiffs were challenging the same law, the religious exemption, the repeal of the religious exemption. So there is grounds under the law in cases like that sometimes to consolidate the cases because the issues are the same and at least one of the parties are the same. But because we were not in the same jurisdiction, the judge denied it. And all that matters is we're not going to be consolidated with that cancer. So we are free and clear to do our thing. And it was an immense victory. And by the way, Kevin, I don't even think I told you this. The home court advantage has already come into play because they were going to schedule the clerk, who I know, former criminal clerk of the court, was going to schedule the status conference 2 weeks out beyond when he did. And I asked him as a personal favor to do it on the 27th. And that's why we got that. So no, I feel like everything right now is in place for us. We're in a good spot.
Yeah.
That sounds great. So I just want to impress upon the importance of the legal sprint that we're talking about. But I know that there are some people here who aren't familiar with the team of attorneys that are working on this. And just to remind you of the cavalry that came together for this, we have, Connecticut attorney Lindy Urso, who's been practicing law in Connecticut for over 20 years. We have attorney Jim Mermigis, who wasn't able to join us this evening, but he's the attorney who kicked former Governor Cuomo's butt all over the courtrooms in New York and was responsible for opening things like gyms, New York City indoor dining, off-Broadway theaters, billiard halls, yoga and fitness boutique studios, and things like that. He had an immense deal of legal victories in New York. And then, of course, Kevin Barry, who a lot of the freedom fighters in Connecticut know because he was there for us by our side the entire 6 years, well, almost the entire 6 years that we were fighting the repeal here. This is truly a dream team that came together with immense brilliance. I mean, the calls that we're on all the time, not to fluff you guys' shorts or anything, but I take notes every time we get on the call because they're extremely smart and we're learning more together every day and we become more confident in our chances every day because of the things that we're, coming together on. So this team is important not only for Connecticut, but for the rest of the United States that have religious exemptions left. And it's also important to the states that have already lost religious exemptions or never had them to begin with, like Mississippi and West Virginia. This can set a precedent and we need all hands on deck. It's now or never. If we don't survive this motion to dismiss, we don't go to trial. We need to go to trial because it will be the only trial like this in the country. And it's going to be spectacular. The brawl in the courtroom is going to be spectacular over this. And I, for one, can't wait to see it.
Yeah, and just one quick procedural thing on that, because the order of work, we're gonna get past the motion to dismiss. Once we do, then it's a preliminary injunction. But even if we lose the preliminary injunction, we're going forward to the trial. That's never happened in the United States.
Mm-hmm.
In California, when they lost their repeal, they tried a preliminary injunction, but the way the tea leaves in California read, there was no point in going forward with the trial. Similarly, in New York, Jim Mermigis and I had some legal challenges there. None of our cases were dismissed, but then COVID happened, and there was we were going to potentially proceed to trial after our preliminary injunction was denied. But then Connecticut was going down, and Connecticut has a Religious Freedom Restoration Act, and New York doesn't at the state level. So it made strategic sense to have Connecticut go first. Let's be successful in Connecticut. If we get a good judgment in Connecticut, we bring it back to New York. So that's the broad strokes of doing that. And one thing I also just want to add, as I'm flashing back to 2019, and while we're actually asking for contributions, is that this legal challenge is not funded by Children's Self-Defense or by ICANN, Informed Consent Action Network. And while we are friends with all those people and we respect what they do, we're not under their funding umbrella. And that I heard that a lot in 2019. It's like, oh, we supported your case. I'm like, no, you didn't. You supported Sussman's case. Because they thought donating to Children's Self-Defense was donated to me and Jim, and it wasn't.
So this is an independent action. The donor box link and the Venmo links are both in the description of this live. I will put them in the comment thread when we get off of this broadcast. I do have two questions for the legal team that I think are important for everybody to see. One is somebody was asking how long you think a legal action like this would take. And the next one is, what would you say to parents who are feeling like they have to get their children on a catch-up schedule before September? Should they wait or should they begin doing that even though they really don't want to? What's your thing? So time frame, and do we start catch-ups or do we hold out hope a little longer?
Well, I'll do catch-up, Linda. You do time frame.
All right, time frame. My best guess is if we lose a preliminary injunction, we probably would get to trial within 9 months after that, something like that, 9 to 12 months. But on the other point, I have a child in that situation who's going into kindergarten, and I have there's other options. But go ahead, Kev. You answer that.
No, well, one of the things I wanted to say about catch-up schedule is certainly wait until after the motion to dismiss, right? Because if we get past the motion to dismiss, definitely do not
Do anything you don't want to do.
right? And that's only, you'll know in 2 weeks, right? So we'll hold off and hold up, make the appointment for 2 weeks out and then cancel it.
Yes, exactly. Again, there is a donor box link and a Venmo link. I'm just looking at some of the questions that are coming in through the, oh, thank you, Amy, for posting the link in the comment thread. We really appreciate that. Matt Paterna is sending love, and we want to send a shout out to Matt Paterna and all his efforts in his camp for fighting alongside us. He's amazing, and we're really happy to have him in our camp as well.
And I also think, for the people around the country, because we're going to take this link and send it around. People who've decided to homeschool, good for you. If that's the decision you've made for your family, but that should be a family's choice, not a choice forced on you by the state.
Right.
So even if it's not your issue anymore, throw in $10 for the single mom who can't who can't homeschool.
Oh, and I wanted to make mention too, there's an option on the donations where you can donate in honor of somebody. So for example, every time I donate somewhere and I can do it in honor of someone, I do it in honor of Christopher Bunch, who is Destiny Maynard's son, who passed away after his HPV vaccine. And I do everything I can in memory of Christopher Bunch. If you have a loved one or somebody that you know was injured, or just somebody in memoriam that you would like to donate on behalf of, that setting is up there as well. I do have a question. Caitlin asks, have any of the other states that lost their RE had a RFRA type law? And the answer to that is no. Connecticut is the first state in the nation that has removed the religious exemption in face of a state level RFRA, or Religious Freedom Restoration Act. So that is why. Okay.
And let me elaborate on that, because I can tell you just from the public comments of the Attorney General and in their motion to dismiss, that the nature of it, they're scared. I think they know they're up against it with the Connecticut's Religious Freedom Restoration Act. I'll just leave it at that.
And I don't know if you want to get into the history of how it passed and who passed it or anything, but people could probably do their own digging on that.
I can do that in 30 seconds.
Okay,
it was passed in 1993 by current Speaker Ritter's father, 147-3. And then somehow in 28 years from the father extending religious freedom, the son gutted it. And it's kind of extraordinary.
Right. So to clarify, our current House Speaker's father passed the religious protection that we're currently arguing 147-3, 28 years ago, and his son just removed the religious exemption in the face of the religious protections his father was able to get codified into Connecticut state law. So it's going to be a very interesting.
And the national RFRA was signed by Bill Clinton and sponsored by Chuck Schumer. So again, what has happened since 1993? It's really extraordinary what's happened in one generation. And
the upside down.
And well, again, religious freedom has been treated like a second-class right for a long time. And I think the judiciary is starting to, check the legislature on that, and hopefully this case will be one where that happens again.
I agree. This is very exciting. I know that we dedicated a lot of time here in Connecticut. We did every single thing that we thought we possibly could, the same as the California activists, same as the New York activists. And if the system was designed to work for the people, or the system worked the way it was designed to for the people, that bill would have never went anywhere. So our last bastion of hope is to seek justice through the courts. And, we can only pray that the judge sees this with all the fairness and the practicality and the rationalism that we are going to offer and makes the best decision. We are not trying to rally or protest outside the courthouse. We need to make that very clear. But the judge could stand to see some younger children there that might want to, go to school someday.
And let's see if some of the statistics, when the trial comes, we'll have a chance to see if some of the statistics the state used to support this action, whether they can stand up to cross-examination and other evidence, because I don't think it can. But nowhere, it's never happened anywhere. This is the first time it's going to happen. It's going
to be really exciting.
Nationally important.
And just for the people who don't understand the legalese, in lay terms, the import of the Religious Freedom Restoration Act is that it requires the state to show, if they're going to pass a law or take any action that infringes on religious liberty, the state must show that there is a it's the highest standard in the law. They must show that there was a compelling interest of the state, and more importantly, they must show that this measure is the least restrictive means to address that compelling interest, which means this has to be the lowest possible thing, the least infringing on the people, least infringing action to raise vaccination rates.
Meaning there had to be no other alternatives.
No other alternatives, exactly, and no lesser severe alternatives. And we think it's very clear, just from a common sense perspective, that they're not going to meet that. But we've got to establish that. But that's what, and I think that's why they're scared, and they have good reason to be.
Right.
We have support coming in from Indiana, from Wisconsin. There's a lot of support coming in and love. We did have attorney Jim Mermigis send a comment in and apologize, offer his regrets for not being able to join us this evening, but he is feeling a little under the weather. He does send his love, and I know that he's resting up and gearing up because he knows that this is going to be the religious freedom trial of the century. So we're pretty.
And we do, by the way, we should let people know we do have our secret weapon down in DC as well, Kev.
Yeah, Attorney Jim Moody is also in the background behind us, and as this, let's assume that we will win this. No matter whether we win or we lose, we're gonna be appealing it, or the state's going to be appealing it. And as we progress, I think this has potential to go to the Supreme Court, and we have Attorney Jim Moody in DC waiting for us there, and he's admitted at the Supreme Court bar, and we'll be ready.
And he's an encyclopedia of legal knowledge of case law.
Brilliant man.
He's a brilliant man. He's been invaluable already, and he's our secret weapon. Yeah.
So we promised it would be over by 9:30. One or two more questions, Leanne. What do you got?
I'm seeing just so much love. There's somebody asking if she recommends that they start actions in other states to introduce bills to bring RFRA to the state level.
Yeah, that's a great idea.
I think there are states doing that. That's an active battleground around the country.
Mm-hmm. For those of us close to Stanford, is there anything else we can do to help in the coming weeks other than just sharing the link and donating?
I know it's a short notice, but if you have a big backyard, Lindy will show up if you have a party where you pass the hat.
Yes, if you want to host an event, I will round up 1, 2, or more of these attorneys, and I'll drag them over there, and we will come and spend the evening in your home. I hope that you'd feed us delicious dinner,
or order pizzas. But and again, I know it's summertime. Everybody's on vacations in the school, the kids or whatever. So just if that happened, we would do our best to make time for it. And, and I think. We want our preference is for the hearings to be in person, right? We want the people who work in the courthouse to see the kids who are being kicked out of school. It'd be very helpful, because it again, like it bothers me the way this community is portrayed, and I'm flashing back to Bath, New York, or one of our cases. They had police in riot gear out in front, and what showed up was patchouli smelling, baby wearing hippie mamas, right? It's the same thing that I've seen in Hartford, where the security guys are getting fed healthy snacks, right? They're coming, they don't know they hear this community of crazy people, and instead it's very intelligent people concerned about the children's health.
Yes, the Venmo is at Liberty Now. And the link is in the comment thread to this live. And once I get off and I'm not in the production studio of this broadcast, I promise to go put the live links in the comment threads of all 3 places that we're streaming right now. We're streaming from Informed Choice Connecticut's public page. We're streaming from my public page. And we are also streaming from Drs. Terry and Stu Warner's Wellness Parenting Revolution, who we got to give a big shout out to for their support, their love, and their hosting us this evening. So thank you to Terry and Stu. We love you very, very much. We will be posting links on all of the streams for this. Now, people are asking how they can stay updated. I'll tell you right now. If you click the donor box link, and even if you donate $1 or $5, you will have the option to submit your email address to get updates on that case. We will be posting updates strictly through that donor box. So if you want the updates, go toss $1 in there if you can and add your name and email address to the list. We're trying to streamline all of the email addresses through this so that we can get all of the communications out in one area. Let me see here.
Also the docket is public record, so you can go to the public docket for the case and follow along yourself that way.
Yeah, we have a lot of moms in here ready to host from all over the state. So I will, I'm going to ask those moms to message me personally on Facebook Messenger, and we will get some dates together to see if we can start hosting some dinners here.
Lindy can eat more hot dogs than Joey Chestnut. So if you're hosting, just be ready.
No hot dogs, just Peronis for me. That's
we have a lot of people offering to add to the legal team. Right now, we have a brilliant group that works very fluidly together. And we feel like we've got our, I's dotted and our T's crossed, but thank you for offering in the suggestions.
Yeah. And also, send me an email or a Facebook message or something too. Cause right before we file, it's not a bad idea. Like when we have what we think is a nearly finished product, running it past other smart people or capable people or people with Connecticut civil practice things who might notice something that we've done wrong.
And honestly, if there are lawyers out there that have access to the databases and they want to do some legal research, we'll take all that we can get. There's no egos here.
100%.
I just want to send some love to our Massachusetts supporters. Sergeant Goodchild is sending love, and he has been a huge supporter of Connecticut from across the lines over there, over at Active Healing. Everybody should check him out, activehealing.org. Thank you for the support from our Massachusetts friends. If you can share, we know that Massachusetts was in a precarious position the last year or two where they've been tiptoeing around removing the exemption in Massachusetts, and their legislature has a very similar makeup to Connecticut's, so it's not unlikely that the same thing might happen there. So it's really important and paramount that Connecticut get on this legal challenge and we survive this motion to dismiss and we take this program to trial. This has never happened, so we need all hands on deck. Smash that button, please.
The best thing you can do to help keep this in Massachusetts is to help us keep this from happening in Massachusetts is help us get a judge to send this back to the legislature, right? If Connecticut's gets sent back, Massachusetts is less likely to pick it up, and same with every other state.
Absolutely. Are we able to speak about an event that our local legislators might want to be involved in, or does this not work with fundraising? You would have to talk about the fundraising aspect with the legislators. I know that there are legislators who do support the actions that we are doing. So if you have friendly relationships with any legislators and they would be either interested in hosting a fundraising event or donating or spreading it to their platforms, that would be very, very helpful. Again, this is a national effort right here. This is a national plea right now for all hands on deck for Connecticut because it's the only trial like this in the nation.
Yeah, a question you should be asking your legislators heading up into this election is that if there's an effort to repeal the state level RFRA law, will you oppose it?
Mm-hmm.
Yes, I was thinking the same thing, Kevin, because if you have legislation, be prepared, because we do feel good about our chances. And in that situation, besides appealing through the courts, the state could try, and as bad as it would look, you never know in these blue states like Connecticut, they could repeal RFRA or do some crazy carve out where RFRA only applies to everything except vaccines. I mean, they can do whatever they want as a legislature. That's the flip side of this, because we're relying on a statute, not the Constitution. So,
on both, but yes.
Yeah, be prepared. Yeah. The more, if you're friendly with legislators, prepare them, educate them, and because this fight can still easily get back into the legislature.
Mm-hmm. And I actually see in the comment thread there are some candidates that are running for very important seats here in Connecticut. Suzanne Witkowski is one of them, running for Mayflexer's district. This is an interest that is very important to the people of that district. So it behoove anybody run for a seat like that to familiarize themselves with what's going on and what's important to the families here in Connecticut.
Yeah, but again, just to perhaps be repetitive, it was never brought up. I was under pain of death by Lindy and Jim if I mentioned RIFRA while this was pending, that I was going to, have to endure some public shame.
You were going to get a sock party on that one.
That's what I'm saying. So it's never been an active thought by Connecticut legislators. What would they do if someone tried to repeal the Religious Freedom Restoration Act? Now it's out in the open. Now it's public record. Now the Attorney General's focused on it, and the governor's focused on it, and Ritter's focused on it. So, it wouldn't shock me if that's one of the first things they try to do when they get back. So tip off your legislators.
Absolutely. Oh, sending love and support from Pennsylvania. Diana, thank you so much for your love and support. We really appreciate you joining in. If you could please share this with your platforms. This is incredibly important for states like Pennsylvania as well, where they have a huge Democratic makeup in their legislature. So I think that the questions that are coming in, there's some questions coming in that we are simply unable to answer. We can only give so much information. We've given a lot this evening. Again, if you want to stay up to date with the most recent updates, go into that donor box, get signed up, and your email will go into the spreadsheet and you'll be included in every update communication that we send out moving forward. And one more time, I'm being asked to explain what RIFRA is. So the federal government has something called the Religious Freedom Restoration Act. It's essentially the 1964 Civil Rights Act, but for religion. It's extra protections for religious freedom that were codified into federal law. Connecticut took that and put it into their state law. They doubled down and made it an additional protection in Connecticut state law. And now that we have that in Connecticut state law, we are the first state in the nation where the religious exemption has been removed with that state level Religious Freedom Restoration Act in place.
Yeah. Just adding to that, this in a nutshell, there was a 1990 Supreme Court decision called Employment Division versus Smith, which weakened the judicial standard for religious freedom. The legislatures, the U.S. Congress, and certain state legislatures, including Connecticut, restored the standard that if you're going to pass a law that infringes on free exercise of religion, it gets the highest standard of judicial scrutiny.
And that was passed by Matt Ritter's father was the Speaker of the House, and Connecticut was the very first state to pass it.
Passed it before the federal government. Yep.
That's right.
Okay. People are asking for details for the location to attend in Stamford. We're not even sure if it's going to be in person or on Zoom yet. Obviously,
if it is, it's 123 Hoyt Street, Stamford, Connecticut. That's the courthouse. It's the only court in Stamford.
And is there a park nearby there, Lindy, or where people could gather?
Park? No. Well, not
we
really.
would just like to make it clear this isn't a rally. Please do not bring signs or megaphones. No shouting anything at any of the staff going in or out of the house.
Comes should be like a mouse. Should be the exact opposite of what we do at the legislative office buildings. If you're going to come, you're just there to bring your children and to be bodies and be support. But if you're going to come to cheer, clap, I mean anything, please don't come, because that's the last thing we need. Image-wise, and particularly for the judge.
No signs for 4 and 5-year-olds. Bring the pre-K and kindergartners.
Right. Okay, great. So I don't see. We already got the location. Latham Park in Stamford is where people are saying you can meet up. Just remember, calm, cool, collected. I don't think there's any more questions coming in. I think we've covered all of our bases tonight. So if you could please take those links, share them within your platforms, let everybody know that what's going on is Connecticut is of paramount importance to every other state that still has a religious exemption or ones that are looking to try to bring it back. Kevin and Lindy, thank you so much for everything that you've done. It's been a pleasure working with you these past few years, and I am so looking forward to this brawl in the courtroom this summer.
Thank you, Leanne.
We are too. Thank you. Right.
Everybody have a great night. Thanks again for coming.